Good evening, everyone, and welcome back to another installment of our Wednesday webinar with the Property Law Alliance. As always, it's so good to have you with us, and it's also good to have our experts with us. How are you doing, Cilna?
I'm very good, thank you. Bit of a crazy week, I think. Bruno, I don't know if I suppose it's very similar for you, but for some weird reason, March is always a particularly busy month when it comes to evictions. I think I actually had a discussion this morning with Michelle Dickens from GPN, and she asked me why that would be. And I said, I think people don't want to commence evictions during like December, Jan, and then by Feb, they still need to, realize they have to pay school fees and stuff. And then by March, they typically have are in better financial positions, or at least perceive better financial positions. So March is always a crazy busy month. So I can definitely say I am looking forward to a hopefully restful Easter weekend. How are you, Chris?
I'm very good. I'm just glad from what you're saying. I'm also just glad that President Ramaphosa didn't put us in another lockdown and where we couldn't travel or anything of that sort. So we're going to have a lot of people traveling this coming week. I'm also urge our viewers to be safe if you are traveling. And yeah, it's going to be an interesting weekend to say the least. Bruno, how are you doing?
No, I'm good. I tend to agree with some about how busy March and April is. So I tend to find on top of the evictions, it feels like another year end for a lot of people. So the same way we refer to Christmas as like silly season or like crazy season, whatever you want to call it. It's typically because people want to get things done. And March, like certain periods in March and April tend to feel like they come to a head and people want results by that time. And obviously because of the public holidays and delays and people going on holidays, you only have, if you don't get it done within that time, clients just see that it's taken a whole extra 2 weeks or 3 weeks to complete. So it kind of accumulates after that. So yeah, there's a lot of deadlines. You try to get things sorted out quickly. So yeah, very, very, very busy.
I think based off of what both of you had just said now in terms of it being a busy month for evictions, that's going to lead me straight on into our first question, which is around the exact point that we're dealing with right now. So I'm going to jump straight into it. The question is that, well, rather the statement is that my lease agreement stipulates that I pay rent on the first day of every month. For the last 3 months, I have been paying rental between the 2nd and 4th day of each month. Now, I've never had an issue with my landlord, and he's always accepted the rental, albeit late, he has accepted it. Last week, I got into a little bit of an argument with my landlord, and I had then paid this month's rental on the 4th, last month's rental on the 4th. And he then indicated that, look, I've been in breach, and he's now sent me a breach letter, terms, and he wants me out the property. My question is, can he cancel the lease agreement on this basis? And can he demand that I vacate? Cilna, I'm going to direct this one to you.
Yes, so I think it's very important to realize that this particular question will never ever have a one-size-fits-all answer, because the content of the lease agreement and the details around the lease agreement will change the answer dramatically. For instance, if the property, I assume it's a residential property, and so in the case of a residential property, I also assume that the tenant is a natural person, and the statistical chance that the landlord is a natural person is pretty high, because you're not going to get into a tiff with a bunch of trustees on a trust or something like that. So if both parties are, well, if one of the parties is a natural person, it's a fixed term lease agreement. Section 14 of the Consumer Protection Act will apply. This means that the landlord will give this particular tenant 20 business days to remedy his breach. The full 20 business days are there for the tenant to remedy his breach, so to effect payment. I have seen attorneys trying to be creative around cancelling but giving 20 days to vacate or something like that. This is not what the Act says. The Act says give the tenant clear 20 business days to remedy his breach. If he doesn't, only then can the landlord cancel. So if Section 14 applies, this landlord will definitely not be able to cancel, because from the facts, it sounds like the tenant paid on the 4th, and then the landlord issued a letter of demand. So with all respect to the landlord, you missed the boat, because you issue a letter of demand after the tenant already performed. So that's important to know. If the landlord issued the letter of demand and the tenant pays even on day 20, remember you can only cancel on day 21. Even if the tenant pays in full then on day 20, the landlord will not be allowed to cancel. More importantly, the fact that a landlord gives you some indulgence or is gracious and allow you, to pay late and not really act on that, does not vary the terms of the agreement. As long as there's a provision in the lease agreement, the heading of a clause like that would typically be indulgences and amendments or variances or non-variation or something like that. If there's a clause like that in the lease agreement that says, even though the landlord repeatedly allowed you to pay late, this will not amend or change the true content of the lease agreement, then unfortunately for the tenant, he is factually in breach of the lease agreement. But like I said, if Section 14 applies, the landlord will only be able to cancel the lease agreement then on day 21, provided that the tenant did not remedy his breach.
Oh, thanks, Cilna.
So just to quickly add on to that, so everything Cilna said was 100% perfect. So the one solution or the one problem. So if I had to speak for the landlord now or give advice to the landlord, the problem is that he can't now all of a sudden issue a breach letter and tell someone to get out the property. The whole point of a breach letter is to afford, and especially in terms of the CPA, is to afford an opportunity to remedy the breach, right? Once a person remedies the breach, like Cilna says, then sorry, it's, that ship has sailed. There's nothing you can do. So from a landlord's perspective, my advice is, listen, you're possibly being overly aggressive. Just be careful. If the person's remedied, there's nothing you can do about it. However, and this is a conversation that Cilna and I have had on a number of occasions when it comes to serial late payers. So the issue here is they had some kind of tiff. The landlord wants to kick him out. That's not going to happen. But if the landlord was sincere, and this was a question of, I need to bring this tenant in line to pay on the 1st of the month, because by the 4th, maybe my bond has gone off. I'm having cash flow issues. I go into overdraft for those 3 days each and every time. And whatever the case is, maybe this has been a point of contention, but not as apparent as the tenant would have thought. In that instance, the landlord is entitled to place the tenant on terms, but not necessarily for the mere payment, because the payments are being made, but rather for the timiest payment. So Cilna and I have had this discussion where we said, for instance, the consistent late payment could be seen as a repudiation, and you could cancel based on that, or you could actually follow the normal letter of demand that it be paid on time from this point onwards, and the next time that there's a breach, actually cancel based on the fact that they did not remedy the breach by paying it on time. So I would definitely consider approaching it from that angle if I were to advise the landlord, just to kind of bring the tenant back into the scope of what the agreement says, because he is technically in breach of the agreement. So you can come down on him on that.
Okay, thank you, Bruno. Thank you, Cilna, for that. In terms of our second question for the evening, it's also eviction related, except the person who asked the question seems to have been evicted from a relationship. So I'm going to get into this one now. The question goes, my girlfriend and I decide to buy a property together. I apply for the bond in my name and it is approved. We agree verbally that she will pay me half the monthly installment. Now, this is after my account is debited by the bank. She then goes on to pay her half share every month for a year. until this past month we broke up. COVID, unfortunately, has severely impacted my monthly income. I want to know, can I hold her accountable in terms of this verbal agreement? Because I don't want to lose the property. So Bruno, I'll direct it towards you, and then Cilna, you can take it on thereafter.
Oh, thanks, Chris. So there's a lot of facets to this question. And so approaching it, there might actually be a lot to say that we might not address very specific detail that that this person may want from us. But on the one hand, what you need to consider is whether there's an enforceable agreement, whether you can get somebody to pay is very different from the ability of actually collecting the money from them. So, and we've had this discussion before. The reality is, even before you look at your merits of any case in law, you do want to kind of assess whether actually proceeding with this claim and trying to enforce it will bear any fruit. Because if the person doesn't have money, if the person's difficult to trace, if the person's going to put up an immense struggle or an immense resistance to fulfilling their obligations, you may want to consider whether legal recourse is actually what you want to do, especially in view of the legal costs associated with it. So that's just the first thing to think of, just from an enforcement perspective, is litigation the answer? Is there something else that we can actually do to make this work? But now let's for a second assume that litigation works wonders and it's simply the press of a button and you can force her to pay. So from this perspective, my argument would be that if there's an agreement between boyfriend and girlfriend, it is still an agreement. So there's a whole concept of commercial agreements between people. You can look at it as a partnership, as a JV. Just because you're dating doesn't make it anything else. So these people bought the property for a specific reason. Now I'm assuming that it's in his name and the bond is being paid. The bond is registered in his name and the property is registered in his name. So it's a bit of an awkward JV, because as much as she's involved in the JV and she's been paying amounts, she's not actual owner as per the deeds office. And so we do need to look at the underlying contract. And I think Cilna will touch on that a little bit more as to the types of underlying contracts that exist between boyfriend and girlfriend in situations like this. But the reality behind it is, if there is a contract, then you should be able to enforce it, provided that the other person also intends to live up to their duties in terms of their contract and enforce their rights in terms of their contract. So long story short, my argument would be, and I don't know if Cilna will agree, but as far as I'm concerned, she's in breach of whatever this agreement is. He's got a golden opportunity now of having this property and keeping it as his own. So I would probably just confirm some form of cancellation, and then she can come after him and sue him for any amounts that she feels should be refunded by virtue of losing this interest. And like this, at least you're placing her in the position to litigate. And he just tries to make a plan now with the property. If he can't afford to pay the bond, unfortunately, either approach the bank or maybe place it on the market, auction it off, just to try, because remember, your credit profile is going to get impacted. And that's the big thing, is as much as you want to enforce it, whether you can or can't, the bank still expects you to pay. So, it's important that you make a plan. You either sell the property or you pay the debt, and then everything else comes second.
Yeah, I agree. In a way, I agree with your solution. Like, take the property and run, and she came out suing for the money that she paid. I must say, I don't think that she would have a valid claim against him. He would have a valid claim against her, because he contracted with the bank, as you rightly said, and I would suspect that the reason why they bought this property together was to live in the property. It doesn't sound like an investment property, am I right, Chris? It doesn't have an investment property vibe. So they were living there together. Now I'm using past tense simply because I assume when you break up, she moved out. I don't know if she just moved to the spare room. If she moved to the spare room, well, except for the awkwardness there, then I would say you would have an argument, then at least to claim some amount from her. But if we kicked her out or she took her stuff and left, I can't see that he will have a claim against her. Even on that verbal basis, even on the tacit basis that she did pay, she paid because she performed, because she received a right of occupation. So I can't see that he would have a valid claim. But I agree with your strategy, Bruno. He has the stronger right, so he can, and the truth is, it doesn't really sound like she necessarily wants to claim the money back, but theoretically, I can't see that she would be successful with that, because the argument would simply be, well, that was for your right of occupation. You paid rent while you stayed in my property. So I can't see that she would be successful. But besides that, I think it's very important for our viewers to understand how these things work. It's all good and well to, you know, be in a relationship, not getting married, whatever the situation is. But remember, if that is the position and you buy property together, it's very much like buying a property with a friend, because the nature of your relationship is irrelevant unless it's regulated by law. And the only things that properly regulated are marriages or universal partnerships. And I think that is what a lot of people miss, because people that live together and for a long period of time, and they buy property together, and even if it's on one party's name and the other one is paying, it can, and at a later stage, be seen as a universal partnership, which has the impact on a relationship similar to a marriage in community of property. So you could end up, by the time 20 years later, if the one party passed away, you can end up in a very difficult situation. Or if they break up, then all hell is going to break loose. That is my best legal term for the day. So my recommendation always to all of my clients is, if you're in a relationship and there isn't any legal basis that automatically governs it, for instance, a marriage, then I would definitely recommend drafting a contract to regulate the relationship between the parties. Because remember, even if everything goes well forever and ever, and you guys live happily ever after, you know, as any good story. Wait, this is the moment you're going to realize how romantic I truly am. Somebody's going to die. And when one of the two parties die, none of the agreements, none of the arrangements will stay in place, because how do you prove this? And for that reason, I recommend always having a cohabitation agreement or a joint venture agreement or a partnership agreement. Reduce what you agree to in writing, because if one of the parties die, if one of the parties suddenly loses their mind and, you know, dumps the other one and moves out, there is no way that your estate is going to survive that, because there's going to be litigation without any legal backing behind it. So before you do something like that, especially before you buy a property together, especially if it's registered in both parties' names. I mean, in this particular situation, it's an easy solution. She's out of the property. He continues paying, and she can sue him if she wants to. But imagine they registered the property and the bond in both of their names. Who has the right to remain in occupation? If they sell, how do they? Who has the benefit? So before you do stuff like that, I'm all for romance. And on my good days, I'm a hopeless romantic. But on my legal days, I am really not. And then I would recommend that you have a proper contract governing the relationship. I'm so romantic, ne, Bruno? Are you impressed?
So you're saying, Cilna, from the very inception of the relationship, everything needs to be in writing. So I should write, "You are my girlfriend, sign here."
Yes.
And it will be governed on a month-by-month basis, renewed.
I buy dinner, you buy dinner. I buy a movie ticket, you buy a movie ticket.
I make the oxtail, you make the rice, you know, basics.
No, lovely. Thank you, Cilna. Thank you, Bruno. So we have another question here from a gentleman by the name of Mangezi Nsomi. Magesi says that he bought a property, and then when he moved in, he discovered that the seller had left an array of junk on the property. He wants to know, can he hold the seller accountable for the costs associated with the removal of this now junk and refuse and so forth? So now I'm going to throw this one to you, and then Bruno thereafter.
I'll happily catch him. So the thing is, I think very often sellers completely confuse the term food stewards for this is not a me problem. And I think that's a very important thing that you need to understand. If you sell a property, even if it's sold food stewards, there are a certain level of expectation that your purchaser will have. And this will not form part of the offer to purchase. If it does, cool. If it doesn't, I must say I can definitely read it in as an implied term without really struggling to make that argument. Potentially even a form of naturalia that you would see in an OTP. So I wouldn't be too worried about now drafting this into every offer to purchase I do, just because you scared somebody leaves their stuff behind. The expectation is when you buy a property and you take transfer, when you are entitled to vacant occupation. Vacant occupation means there is nobody and none of their stuff, unless the parties agree to furniture or stuff. Then it means vacant property. Similar to, let's talk about commercial property rentals. When you white box a property, there's nothing, you're not going to white box a property and give it back to Grove Point at the end of your lease with your rubble still there. You have to move that. So similar with a seller, you can expect the seller to remove their stuff. And the truth is, if you already took transfer and you're already in occupation, you can definitely demand from the seller that they attend to that. But if they don't, the problem that you have is the refuse removal is going to end up costing, let's call it 2,500 Rand, depending on what it is, but like typically cleaning sort of stuff. And to go into litigation for that once again, I don't know if it's the wisest, but for that reason, I always recommend during the transfer, if you are entitled to possession and occupation on date of transfer, attend to the property once the conveyancer informs you that the matter has been lodged, that the transfer has gone on lodgement. That means it's going to transfer in the next, depending on the deeds office, let's call it 3 to 5 days. And if you know you're on lodgement, visit the property, make sure everything is in order, because at that stage, you can still ask the conveyancer to hold some proceeds on trust. So just to cover the important parts of yourself, that would be an easy recommendation.
No, I fully agree. I can't actually add anything to that.
Important parts. This is what happens if I had a long month. I have very interesting ways of explaining things.
Indeed. Let me quickly, while we still have some time, jump to the last question. The last question is by a person by the name of Marlene Nyezi. And she wants to know, can I transfer documents? Can transfer documents be signed electronically by the purchaser, or is an original signature required? Now, I'll throw that to Bruno. I do have 3 little short questions here, so we'll go first with that one to Bruno.
Sure. So electronic signature, as we explained before a couple of times, the problem is that some elements of our law are still somewhat archaic and haven't caught up to the times. The reason for this is because there's a lot of case law regarding actual verification and proof of the actual signatures and whether the real person signed it with handwriting experts and that sort of thing, right? And the legislation hasn't caught up. So when it comes to deed of sale, for example, has to be in writing. Deeds registry also expect all the documents lodged at the deeds office to be in writing. Deeds office feels comforted by the fact that they receive original documents that the conveyance certifies as being original. Remember, part of your transfer documents are affidavits that, typically speaking, or not even typically, that has to be done in front of a commissioner of oaths and is always done originally. So you can't get away from that anyway. So even if it is just for those documents, you need to sign them in front of someone. The transfer documents, on the other hand, yes, those ones one feels that they could be done electronically, but unfortunately, deeds registry doesn't allow for this. The specific legislation doesn't allow for it. If I can advise anyone, it's really not that bad, because ultimately, if there's a postnet next to you, you simply go there, you print everything out, and you don't have to drive to the conveyances, because that typically tends to be an issue where the conveyancers insist that they come and sign before them. You can actually make arrangements to sign these documents. The conveyancers would often even make arrangements for you. They would find an attorney very close to them, very close to you. They would let you go there, get them to print it, pay them, I think, something small like 400 Rand or something. They'd print all the documents, sit with you for 20 minutes, run through them, and get you to sign in all the places. So we very often act as correspondents like that for some conveyances, for people to come sign. So it's really not that bad. It's an arrangement that is made. So yeah, unfortunately, it's not convenient without electronic signature, but it can be made convenient if you are insistent that for some reason you can't travel to the attorneys for whatever reason.
Thanks, Bruno. And I think quickly into the second question now towards Cilna. Cilna, do the documents have to be lodged in the same province as the property? I'm assuming here that Marlene is obviously experiencing a situation where she's out of the province that she's now purchased a property in.
Yes, and well, not unfortunately, the deeds office isn't, well, the deeds office is one thing, it's like the High Court, but you have different deeds offices. And each deeds office has jurisdiction, meaning certain areas that it is responsible for. And your title deed is registered with a specific deeds office. To transfer, you can only transfer in the deeds office where that title deed sits. So if your property is, for instance, in Nelspruit, you will have to transfer in Nelspruit deeds office. If your property is in Durban, you will transfer in Durban deeds office. You can't transfer in a different deeds office.
Unfortunately, if your property is in Melrose Arch in Joburg, you have to transfer in the Pretoria deeds office.
How funny is that? That's my best. Every time you do a deed search, you're like, huh? But sort of north of Joburg, the entire north is, not the entire north, a bunch of the north sits in Pretoria deeds office.
Wow.
Yeah,
no. Yay, lawyers.
So Marlene asks a third question, and she wants to know, does the purchaser have to pay rates pro rata for 3 months if the property falls under, and I'm guessing this is where she bought the property, the Mfuleni municipality? I'll open this up to both of you, because with municipalities, I'm assuming that the law can vary. So Cilna, you can go first, and then Bruno.
We are so polite. Well,
always ladies first.
Usually, why is Bruno then first sometimes?
That makes no sense.
Or does
it? So now, usually it's 3 months, and it's quite a standard amount of time, but the municipality is entitled to charge whatever amount they typically foresee the rates clearance and the transfer to take. If they asked for 6 months and transfer takes place sooner, obviously the conveyancer will just sort it out, and the right party will pay the prorated up to transfer seller from transfer purchaser. So it's usually 3 months is a very standard time period that you see from municipalities. Towards the middle and end of last year, there were municipalities that charged a longer time period because the deeds offices continuously open, close. So they asked for a slightly longer time period, but 3 months sounds quite reasonable. and the clearance departments are allowed to change that and request the clearance figure as they see fit, considering the particular circumstances.
Just quickly to add on that, as Cilna mentioned, the reason for this is because transfer takes a certain period of time, so the municipality wants to be covered for the entire period, which is why clearance figures lapse and certificates lapse and things like that. So as a solution for the viewer that asked this question, or listener, viewer, what you can do is grab some bridging finance. So if cash flow is an issue, the thing is, because you're in a position where you're giving transfer of the property. Now, this is assuming naturally that you're the seller. Since you're giving transfer of the property, there's a very high probability that you will be receiving money in the form of proceeds. So bridging finance companies would be willing to assist to bridge, get the clearance certificate, let the transfer pass, and then collect from the proceeds of the sale. So again, a solution for you is get the conveyancer to arrange a local attorney, get bridging finance for these amounts, and get a conveyancer. And even your local conveyancer can lodge in another deeds office, because we all have networks. So I can do transfers in Cape Town, Durban. It won't actually cost you a cent extra. So as far as you're concerned, you're comforted by knowing you've got someone that's very close to you, and then we do the job across the country. You won't even know. So yeah, speak to the conveyancer. They should be able to sort you out with all these things.
Thanks, Bruno. Thanks, Cilna. And that brings us to the end of today's weekly webinar. I just want to say thank you again, Bruno, Cilna. Always amazing to have the advice that you guys give to us, and to the viewers as well for joining us. We are going now into this long weekend, which we spoke about earlier. So I would urge you all just to be safe, to take precautions, and to ensure the safety of your families, but to also enjoy yourself. And then to post your questions in our group as well when you have some time on the weekend, so we can get to them on our next webinar. So thank you, everyone. Thank you, Cilna. Thank you, Bruno. Cheers.
Thank you.
Chris.
Bye-bye.
Bye.